And we are recording to the cloud. We're at 100 participants and it's climbing rapidly, so I'm going to give it another 60 seconds. And I'll shave this off and when I post it to YouTube this afternoon. Okay, let's begin. Welcome, folks, to this webinar sponsored by GW Law School on opening online marketplaces to government micropurchases. When we originally scheduled this webinar about a month or so ago, we did not know what was going to happen last Friday. Last Friday, as most of you know, the General Services Administration awarded contracts to 3 vendors to open up these micro-purchase marketplaces. It's a very exciting development, and we have an enormous amount of international interest in this. We've had signups from over 20 countries around the world because this model, which is opening up Amazon-type marketplaces to government purchasing, may well be used elsewhere around the world. Just want to address a couple of administrative things before we start. We did receive a question whether or not the recording will be available after the session, and the answer is yes, it'll be available, in fact, publicly. I'm going to post it to YouTube, and then I'll be putting a link to that into the program information page at publicprocurementinternational.com. The YouTube version by later this afternoon, after it's had an opportunity to process, the YouTube version will be available in over 100 languages. I'm going to do a little bit of introductions, and I'm going to open up the floor to panelists. We're going to have a question and answer session at the end. We've left a substantial amount of time for questions and answers, and please feel free to ask questions as we go through. There's a Q&A function here in Zoom, and the Q&A function is awkward to use. So please, if you're going to ask a question, ask the question. You can ask it to the panelists, or you can ask it to the audience at large. But please ask the question in the chat. The public questions, the questions that go to the audience at large, will be saved. The chat is actually saved, and I post that as well on the program site. There are some resources available on the program site as well, publicprocurementinternational.com. Just wanted to highlight those for you. There's a couple articles that we've done in the government contractor that may be useful background. There's also links there, a descriptive link to the Commercial Platforms Initiative at GSA. GSA posts all the documents, all the key documents regarding this initiative at its website, the General Services Administration website. And also available through a link is the Department of Homeland Security report on dealing with counterfeiting on e-commerce platforms. That Department of Homeland Security report is an important one. It was actually cited by Emily Murphy, the GSA administrator, in the press release that went with the awards on Friday. It's a worthwhile resource. It's one worth looking up. And again, all these resources are available on our website, publicprocurementinternational.com. We're joined today by several supply chain professors from around the country. Rob Hanfield is from North Carolina State University. Thomas Call is from Arizona State University. Andrea Petrucco is from Penn State University, but he's moving to Florida International University in Miami. We're delighted he could join us in the midst of his move. We originally invited GSA, and GSA it had to decline. We weren't sure why until we saw the award information last Friday, and suddenly it was clear why GSA couldn't participate. Roger Waldron from the Coalition for Government Procurement, who has really written extensively on this and knows this topic very, very well, was very kind to join us. Roger has worked with us extensively in our program. The Coalition for Government Procurement sponsors a very important scholarship for veterans in our program. We're very grateful for that. They do an annual August golf outing for us. We really are very grateful for their participation. And Roger and I he actually participated in my procurement reform seminars. We were putting it online. Roger very kindly joined me for that. So I'm delighted he could be here as well. I want to give you a little bit of background on the program, on the initiative at GSA, and then we're going to take a deeper dive with the supply chain professors, talking about from their perspective, both from Rob's perspective and from Thomas's perspective, how this fits into the supply chain theory in general. And then Andrea is going to bridge from that into a state perspective in the United States and also an international perspective. And then we'll be looping in with Roger. We'll be talking about the finer details of this initiative. So the initiative was launched by Congress under Section 846 of the National Defense Authorization Act for fiscal year 18. GSA opted to focus on commercial platforms as it was building out this initiative. GSA could have taken other approaches, and the initial reports that are available on the commercial platforms website they talk about other approaches that GSA could have taken. For example, GSA could have used private technology to amp up its own electronic catalog, which is called GSA Advantage. GSA Advantage could have been improved using commercial software, but instead GSA decided to open the door here to private commercial platforms, such as Amazon. Section 846 would have allowed GSA to go all the way up to the simplified acquisition threshold for purchases, but GSA, after a long back and forth with industry and with other stakeholders, decided to limit it to micro purchases up to $10,000. There's an ongoing issue regarding use of data, which Roger will be focusing on. When a vendor uses this portal, when the vendor puts something on Amazon, what will happen with its data? And Congress was quite clear originally in Section 846, and then in Section 838 of the National Defense Authorization Act for the next year, for fiscal year 19, Congress was quite clear that the portal provider, the portal, should not be misusing for commercial purposes, should not be using third-party supplier data that it's getting. There were 3 contracts awarded on Friday. They were awarded to Amazon Business, to Overstock.com, and to Fisher Scientific. Amazon Business, most of us are familiar with what Amazon offers. Overstock.com offers more of a motley collection. It offers furniture, but it's offered computers as well. And Fisher Scientific tends to focus on scientific equipment. Amazon Business is I think by any measure, is the broadest portal in terms of what it's providing. The idea is to have a proof of concept for 3 years with a possible open season. GSA left open the possibility that it will open the initiative again to other portals as well. The platforms are set to launch in 30 days. There's some confusion about whether or not services, clearly goods are provided for. Attachment 5 to the amended solicitation says services are not allowed, but there was a back and forth between GSA and offerors, a question and answer where GSA made clear that services should be allowed as long as it's a product-focused portal. And in that, the back and forth, that was part of a broader set of questions where GSA was making clear that it wanted to accommodate commercial practices. And of course, Amazon does allow services as well. There are services for sale on Amazon. GSA expects that the data that it will be getting will assist GSA and its customer agencies in addressing compliance in areas such as Agility 1. Probably some of the most difficult issues in implementation will be how these portals can accommodate the preference for socioeconomic programs such as the Ability 1. And there was an amendment to the solicitation during the course of the contracting process that allows the portals 120 days to accommodate those preferences under FAR Part 8. Cybersecurity continues to be an issue. What types of goods are being provided? Do they pose some cybersecurity risks to the United States? Roger will be talking about that in more detail. Part of the process here was that GSA made clear that the proposals, the offers, would be reviewed by the Federal Acquisition Security Council, and that they could be rejected if the Federal Acquisition Security Council found them unacceptable. Just to give you an idea of the scope here, GSA estimates that the addressable market will be $6 billion. They're very careful. You read the Q&A with vendors. GSA was very careful not to overpromise. They said that there might be a slow growth here, but they estimate $6 billion. If you look at the GAO reports from the past few years that talk about micro purchases in general, those micro purchases numbers are much closer to $20 billion. So it's very possible that this initiative would grow to something close to $20 billion. Now, just to put it in scale, it's a $500 billion marketplace. It's a huge marketplace, but $20 billion would soak up a great deal of smaller purchases that are being made. And this is an important change. I just want to close with one note here, and just something to emphasize. This is the first major procurement initiative that is focused on user purchases. These purchases can be done by anyone with a government purchase card. It's essentially a government credit card. So for the first time, users will be able to bypass the normal procurement functions. Will not have to go to their contracting offices. Will be able to make the purchases directly. So this is a radical change, and that explains partly why there's so much international interest in this. That for the first time in this U.S. experiment, we're allowing users to purchase directly, and that could have profound impact on how these procurements done, and how more broadly how public procurement systems are shaped. So with that, I'm going to turn it over to Rob.
Well, thanks very much, Christopher. And this is indeed a really exciting event that we're witnessing here. Just a little bit of background. Much of my work in the private sector, is focused on transparency and visibility, and certainly the digital revolution that's impacting supply chains. And in our latest book that we're working on, we're also talking about the idea of supply chain immunity, which, as opposed to resiliency, really refers to the ability to flex, to be more agile, to deal with different events such as COVID. And I've been working quite a bit on COVID. The move towards these online marketplaces, in my mind, I think has some positives, and there are some risks, like any situation. For example, I know we work with the American Red Cross. They recently moved to Amazon Business, and they have a tail spend of something like 30,000 suppliers, and I wrote about this on my blog. And they had great success with that deployment. They were able to reduce their cost by up to 15% in some cases, enhanced user experience, greater efficiency. And one of the big benefits was they also were able to create better spend data to be able to see where those purchases are and to track them. The issue, of course, is, there are some risks, and key to those risks are the issue of transparency. And Amazon, has a reputation, and we discovered this in a study on counterfeiting, that they are a gateway for counterfeit products, and they don't do a particularly great job of controlling that. It's very difficult to control. I mean, the problem of counterfeiting in general is difficult to manage, but e-commerce is definitely a gateway for that. The other issue, and I think one of the people who pointed this on the question, is how much transparency do you have into the social compliance practices? In the UK, the Slavery Act mandates that public procurement has to verify that the supplier has complying with social human rights, workplace conditions, etc. With a lot of these things coming from China and overseas, that visibility is certainly limited when you're using a third party like Amazon. And likewise, issues around being able to track minority, women-owned hub businesses. I think that could be another issue that would come up. So there's a lot of issues in general, I think, that have to be addressed. One of the benefits certainly is past performance. It's something that GSA and the government in general has struggled with in the past, is sort of scorecarding suppliers. One of the benefits of this is that you will be harnessing the collective intelligence of the government acquisition community. and you can start to collaborate amongst one another, and identifying, using the Amazon rating systems to highlight those that are in fact, dubious transparency, dubious origins. Maybe the country of origin isn't what they claim to be, versus those that have a strong record of performance and are delivering on time and the quality is there, et cetera. So there's a lot of issues here, and I think we're only going to really scratch the surface on this webinar today, but those are some of the things that I see. You're on mute, Chris.
I can turn over to you, Thomas.
Yes. Hello, everybody, and thank you for joining our webinar. So similar to Rob, I've been a supply chain professor for quite some time, and my interest has been more recently turned towards providing access to traditionally non-procurement people to teach them procurement. We just recently launched a mobile simulation for healthcare workers in developing countries in Ghana, and it's been getting some traction there, and with the whole point of recognizing the fact that a lot of non-procurement folks, these were pharmacists and nurses, they're doing supply chain management, they're doing procurement. And so with that recognition, I looked at, was very excited to get involved with this conversation to highlight that, studies have shown in anytime implementing e-procurement, e-marketplace type initiatives, the human resource side always is a major factor in whether or not the goals are achieved for the expectations of either the efficiency or the effectiveness of such a platform. And so, in fact, Chris pointed out to me just recently that the FAR really encourages the implementation of training. Whenever implementing the new and kind of modern methods, training should be accompanied this. And one of the first thoughts that I had was that although training comes in many different forms, and one of the forms could be simply just training in the tool itself and navigation of the screens and whatnot, and that could be quite complicated. But really, I think we should not forget that training needs to include procurement, or the process of sourcing. We takes quite some time in training professionals in the process of procurement, but you still need excellence in procurement whether or not you're a professional. And with we're talking, if the expectation of $20 billion in spend here, we still want value for money. And to achieve that, we still need to follow the basic sourcing process to do it right and to do it well. It was kind of funny. I took a quick look at the GSA Advantage site, and I saw, I just typed in toilet paper, and you would think that'd be easy to choose, but I think there are either 25 to 50 different choices of toilet paper, and I don't know about you, but I have some specific requirements on that. And if you're going to be sourcing, if someone in your office is going to be using the P card, you kind of want them to keep the end user in mind for sure, and be understanding of the requirements, know what capabilities all the various products and services. Services even more important to understand that. Analyzing alternatives, and then following up and making sure that the procured products are meeting satisfaction, and to make adjustments. And some of the, if you look at the Amazon Prime for Business, there are many tools beyond just the simple procurement process steps, the transaction. There are some more analytical tools that are there. And I would think that it would behoove power users especially, to get to know those tools, and they can do well for their agency, their division, their work team, to analyze those to their advantage. And I think that does take training. Just giving someone often you have to know what questions to ask. You just the systems won't answer all the questions you need. So I think that going forward, I would encourage, typically as a professor, you always sell education as the as an important element. and I want to sell it. I'm here to sell education. I think a deep assessment of what people do know and the training that's going to be imparted with this is important. And then there are many different tools out there for learning. It doesn't need to be formal. There are some informal free tools for education. There are also micro-credentialing that's out there as well. A lot can be done online. Of course, look at simulations and other learning tools. But this will take time, and I think that planning now, anyone in the future is going to use this should plan now and expect that this is going to be an important point to making this initiative successful. Thank you.
Thanks very much, Thomas. So I'm going to turn it over now to Andrea.
Thank you so much, Chris. And again, also from my side, hello to everyone. Thank you for attending. It was a pleasure for me to be engaged in this discussion because I come from Europe, so I had the opportunity to deal a lot with the topic of e-procurement, e-commerce, e-marketplace in Europe, and seeing this initiative here in the United States provide me with also a view on a country where that I'm start to dealing with since I arrived here. I think that, I mean, independently from the country, the topic of e-marketplace is incredibly up to date, especially considering the period. And as Chris was saying, the GSA initiative, it's a pioneering initiative in the field because it doesn't simply provide any technological improvement in terms of platform or functionalities. It's an improvement in it's a new business model. That open new, let's say, perspective, a new possibility to advance the dynamic purchasing system for micro purchases. So that's why it's relevant to be presented to a broader audience because it's an innovation in the business model, which may be perceived in different way across the world. And second, of course, and I saw already someone that posted something in the chat about it. Like this provides the possibility to centralize the spending for this type of purchasing, which are usually common and standard, and they are almost the categories that are mostly out of control in public institutions, but also private institutions. So this gives the possibility to rationalize a little bit the demand and also to collect data about these micro purchases, which means in the long run, understanding better the requirements, improve the offer, which means also improving the value provided through the platform. And how this will work, we'll have a different, we'll collect different interests in terms of state, regional, local level. Like, for example, we have had a lot of discussion going on here with the state procurement officer, which are very interested because there is a lot of attention on the potentiality of the new marketplace for public procurement. For example, we know for sure that NASPO Value Point is planning to release any marketplace RFI in the next weeks or in the very short. Which will include the e-marketplace elements, which are more customized on states and needs requirement, but like we are getting there. So seeing the dynamic of the GSA initiative will also be helpful to understand how this will go through at the state level. Similar, let's say, interest we can see it from the local government perspective. I mean, historically, local governments are the public institutions that are less like mature in the use of technology or in introducing process innovation in the procurement process. There is a lot of discussion going on between state and local governments on which type of technology should be used to make the procurement process management easier. Predicting the perception and how much they will actually use this type of tools is not easy, but for sure, from our side, we see a value in this type of innovation, and I think there will be value also for the local government perspective. Like the issue here will be make the local government perceiving the value of using this technology because local government traditionally, and that's my personal opinion, they are not just using the technology because it's technology, they are using it if they see, let's say, an actual improvement for the process. Otherwise, the technology will will not be largely adopted. But again, with the improvement of the fact that the user can buy directly to the marketplace, that can simplify a lot the bureaucratic procurement that usually affect this type of institution. Personally, I would be also interested in seeing how like European country will react to this initiative. We know that, of course, like the directive is different. We have different regulation, which is also very fragmented at different country level, regional level. So the context is different, but the topic of e-marketplace is very hot there as well, especially during this period, because the marketplace scenario, the e-commerce scenario in Europe is very fragmented. And I had personally the opportunity to collect views about what e-marketplace, the role that e-marketplace plays during the COVID-19 emergency. And what we can see is that we had, like countries have a very heterogeneous response in terms of usage of e-marketplace for the provision of critical goods, because a lot of countries, and I saw that someone posted as well for India. They say that e-marketplaces are very useful. They were very useful during emergency situation, but there are still some issues connected to e-marketplace, such as the quality, possible counterfeiting, supplier liability, and so on, which might, let's say, limit the adoption and the usage of this type of tool. In Europe as well, during these months. Several organizations, I mean, I know for sure Crown Commercial Service in the UK, they open an ad hoc marketplace just to support the needs during the COVID emergency. But again, the level of adoption and the usage was not as expected. So I'm sure that in several countries in Europe, there will be interest in seeing how the GSA initiative will enter the market, but again, there will be a lot of discussion on how much this business model will be actually replicable in different countries and in that context. And I'm sure that a lot of these aspects will be clarified by Roger, which will come immediately after me.
Thanks very much, Andrea. Roger, floor is yours.
Oh, thank you, Chris, and thank you to George Washington University for inviting me. I appreciate it. And I guess if you want to go to the next slide, I guess what I would first say, Chris, this is the gift that keeps on giving for a law professor here, because there's so many different issues from a public policy, legal perspective that come out of the e-commerce initiative. That you're going to have hypotheticals and questions for your students for the next 5 to 6 years as this all plays out. It's very, very fascinating stuff. And really, at the end of the day, e-commerce is highlighting the fundamental things that we focus on in procurement in the federal space. First of all, fair and reasonable pricing. What is that? Also, process, streamlining, reducing hurdles to access to the market, and how those processes work, the balance between full and fair competition versus, streamlined access. And then lastly, compliance and requirements. Those are, to me, those are the fundamental things at the end of the day. And compliance can be government unique requirements because of the public fisc, but also agency-specific mission needs and how you're meeting those. And this e-commerce initiative highlights all these things and raises all kinds of interesting questions. And I'm just going to try to run through these real quickly, if you don't mind, and I'll just highlight some of the questions as we move forward, looking at the awards and then the performance of the pilot. Here's just some of the things I think folks are going to be tracking, asking about, looking at. We know GSA will be looking at these as well. So first, limiting the scope of the e-commerce platforms. Real quickly, the Section 846 is a very broad statute. GSA, in its research, identified 3 different models of e-commerce that were eligible for participation under the statute. The e-marketplace model, which is akin to Amazon. E-commerce model, which you could think about like going to Staples or Office Depot or their websites or Grainger's website and ordering directly from that their e-commerce site. And the last one is e-procurement. And that's like business software that helps a buyer set the parameters and rules or screens product for them. You could think of that. And I'm using company names because it's easier for folks to identify. It's like SAP Ariba, for example, as an example of that. So GSA in its pilot chose to only include, at this point, the e-marketplace platform. So it'll be interesting to watch to see as they move forward whether they'll expand the pilot to look at e-commerce platforms, to do a pilot with regard to e-procurement software, to support and then do an assessment across the different models to see what makes good sense. Is it a mix of these? How should it all work? We'll be following that. It's going to be interesting to see where GSA goes on that. Fair and reasonable pricing. This is a big issue, obviously. Chris knows in federal procurement, it's all about the price in many ways. And looking at this, the question here is, what is the price to the government just in terms of price? So GSA is charging a fee to customer agencies for use of it, 0.75%. So it's not a no-cost contract. And then the cost of the product include whatever fees that the platform providers are charging the individual companies. So the ultimate price that the customer pays, whether it's a private customer or the government, is going to incorporate that fee. Are the fees reasonable? Are the fees a barrier to entry for companies? What is the overall price that's being paid? There's been studies in the past that show GSA schedule pricing in many instances is lower than on e-marketplace platforms. So there's going to be an assessment and looking at that, I predict, across that. Country of origin. This really goes to the Trade Agreements Act at the end of the day, and identification of country origin. And of all the issues that companies care about, that I hear about, the TAA is the leading one. Because the TAA does not apply to the platform. So products from non-TA compliant countries can be bought through this program. So you're talking about China in particular. And companies feel like, or want to understand where the government's going in this regard, because under their schedule contracts and other IDIQ contracts in the government, the TAA does apply. My prediction is these two disconnects cannot stand over time, that it's going to go one way or the other, that either the program will adopt TA compliance requirement, or these other contracts are going to have to change and address that for transactions below $10,000, the companies do not have to provide TA compliant product. This highlights that disconnect in our procurement system, and it's going to be addressed one way or another by the platform. Organizational yes.
Some stuff in here, and just for the audience, so one of the things we did preparing is that Roger's, because Roger's talking about the meat of these issues, that we're going to have a back and forth so the audience can follow.
Sure.
So on the country of origin issues, Roger's reference to the TAA is the Trade Agreements Act, and the Trade Agreements Act generally provides that countries that have not entered into free trade agreements with the United States, such as China or India, they're not allowed to sell into the federal procurement market. And this is an extremely important bar. It means that companies that are selling, for example, on the GSA schedules, which is a sister procurement channel, they have to ensure that the items that they're selling are not coming from China. And that's a big deal. It's a huge compliance burden. If you look at the solicitation for this contract, for this procurement, the only requirement, there's really no requirement regarding country of origin. Users are allowed to take country of origin into account when they're making their purchase, but there's no bar like there is under the Trade Agreements Act because it's below the micro purchase threshold. And also it's, because these are smaller amounts, but the same small item on the multiple award schedules would have to comply with the Trade Agreements Act. I just wanted, if I could, just talk about the fees issue, Roger. And this is really important. So the way the solicitation process was set up is in a standard type contract of this type, the standard type solicitation, there is a statement of objectives put out by the agency. The statement of objectives essentially disappears as the contractor puts forward a performance work statement. The performance work statement then becomes part of the contract. And in this case, it's really important because the performance work statement will describe what the buildup in fees are. At least it should, according to the solicitation. Do you see a process, Roger, unfolding where the performance work statement and the broader contract will become public soon so that vendors can understand what might be happening in the context of these portals, so that vendors that are considering whether or not they should join Amazon, for example, will understand what the fee buildup is?
I think that should be made transparent. I think the key to success for the program overall is that kind of transparency. So companies are going to want to understand from a business perspective, what does it mean to participate from a cost perspective? Because it goes to their margins at the end of the day. If they're paying, what level of fee they're paying the marketplace provider, whoever it is going to factor into the price that they can actually charge the end user. Yeah, and then the flip side of that, from the government customer perspective, they're going to want to understand the fee structure and what the government is paying the marketplace provider as embedded in the price, overall price, for purposes of saying, hey, does it make sense for me to use this? Or are there lower prices on other IDIQ contracts someplace else? I think key to the success is the transparency in these things. So I would hope that it's made public relatively quickly.
Okay, thanks, Roger.
Real quickly on organizational conflict of interest, Chris, this is the issue you mentioned with regard to the prohibition on the use of the transactional data by the marketplace providers for their own competitive purposes. It's a fundamental, that and TAA are the two big issues that we've heard uniformly from companies, making sure that that transactional data is not, compromised, their transactional data is not compromised in any manner is vital to them. And ultimately, actually, too, that data is also owned by the government. So, so there's that side of it as well. DHS report, I think we'll talk a little bit about that a bit more, but that goes to the counterfeit issue, the vetting issue, and the integrity of marketplaces overall, and administration putting a stake in the ground saying, hey, moving forward, collectively, and it's collectively, it's government, it's the suppliers, it's the marketplace providers working together to ensure the integrity of the markets. The dual procurement universes is what we've kind of, Chris, we've just described, in that there's a host of government requirements like TAA, negotiation, fair and reasonable pricing, that go with traditional government contracts like the GSA schedules that do not apply here. So you're creating parallel universes. And again, I think these are going to be harmonized at some point along the way. The next slide.
Can I just ask a couple of
Sure.
questions here, Roger, on this? So Kyle Chadwick, who's asked whether or not there'll be an uptick in disputes under this, and that's hard to tell because the individual orders that are being issued are going to be individual contracts, and whether or not those will devolve into disputes is an open question. I think it might be useful to approach the problem slightly differently, and through the DHS report you cited, the Department of Homeland Security report pointed out the fact that there's a huge problem with counterfeits on electronic portals such as Amazon. And their recommendation was, and this was really picked up by Peter Navarro in the White House, would be to debar vendors that are providing counterfeit goods as part of a broader effort on the part of the United States to bar counterfeit goods from China. So on this angle alone, there's likely to be more debarments on this question alone with regards to counterfeits. But more broadly, Roger, historically, a government contracting officer is looking at issues of technical evaluation, looking at price, looking at past performance, and looking at responsibility, at qualification. Almost all those issues fall away when a user is making a purchase in 30 seconds. A user is not doing a technical evaluation, is really not doing an in-depth past performance evaluation. The price reasonableness determination, Roger, they only have to look at two like products. That's the price reasonableness determination. So all we have left really is qualification, whether or not this vendor should be on the portal at all. And again, you see in the solicitation, and I just want to know if you see it the same way. I really foresee, Roger, a huge uptick in debarment actions, especially by vendors who are incumbents on the federal marketplace and suddenly see new low price, low quality vendors coming in through the portals. In order to challenge them, they would seek debarment through, let's say, through the GSA suspension debarment officer.
Chris, just a quick comment on that. The debarment is difficult. It has its own issues. And Amazon sees that today where they'll debar a supplier and they'll pop up as somebody else under a different name, selling the exact same things. So there's challenges with debarment as well.
No, absolutely. Roger?
And I think this, Chris, you're just highlighting the, some of the fundamental issues we'll see play out in the pilot is, in many government-wide contracts that GSA does, there's a vetting process and a review and evaluation before an award is made, and then customers can use those contracts. Here, is there an analogous process going to be put in place? It goes to the fundamental issue that many people looking at, the future e-marketplaces is what role in screening products and counterfeit and that sort of thing, and what responsibility do e-marketplace platforms have in ensuring that the customer can rely on the products that they're purchasing? Because to your point, you're going to looking at a GS 9 or 10 who's been asked to use their purchase card to go buy something for the office. So what is it? Are they buying a laptop? Are they buying, you can buy a server, for, $1,000 on a platform. Where'd it come from? Is it a Huawei? That goes to the next slide. So here, other government requirements, Ability 1. So under GSA schedule contracts, the contractors who sell Ability 1 products have to block essentially the same commercial products. And there's a whole list of those items. And that's an affirmative responsibility of their schedule contracts, so that the customer only sees the Ability 1 product. So the question is, how will this platform provide for that? Is it another case of parallel universes where under schedule contracts or other contracts, there's an affirmative responsibility, but not in the platform place? Again, supply chain issues. You mentioned counterfeit, Huawei. Are Huawei products going to be listed and available for purchase by government customers? They technically shouldn't be, can't be, right? But there's Section 889 in place. How is that going to be addressed? I think very interesting questions there.
Can I just throw Roger in here on, because I've gotten a couple questions in the chat session about the Ability 1 and the other preferences like the federal prison industries. Just to be clear on this, I don't want to give short shrift to the Ability 1 requirements, which are really intense in the solicitation. In essence, we've got a comment in where one of the participants said, no, it's more than steering, is that the portal will actually have to, when somebody's trying to buy something that's on an Ability 1 list, the portal will have to say, raise a red flag and say, no, you have to buy it from Ability 1. So this is a major compliance lift, a major compliance burden for the portals in order to steer purchasers away from other offerors on these platforms to the Ability 1. And that really, it actually has a regulatory basis, is that the micro purchase regulation, FAR Part 13, actually cross-refers to the requirements in FAR Part 8. And that's where the requirements regarding Ability 1 and the federal prison industries appear. So for legal reasons, the portals are going to have a significant lift within the next 120 days to explain how they're going to do it. Now, I just want to ask you, Roger, just a question here I want to ask about Huawei, okay? So the master contract says that Huawei is not going to be allowed, okay? But that's a different contract, Roger, from the individual orders that are being issued. So we have an open question. This is something that may end up with the folks at the Civilian Board of Contract Appeals. What's going to happen if someone sells Huawei directly? Are they covered by that bar? The answer is,
well, the prohibition on buying Huawei equipment applies below the micro purchase threshold. It applies to all purchases by the federal government. So either the contracting officers made a mistake, it's not blocked, or the third-party seller also. I mean, it's really probably all three are responsible in some sense moving forward. And that goes to issues that were raised by Congress and looking and asked that there be a closer examination of higher risk product categories like IT or healthcare products with regard to whether or not those should be included on a platform. It'll be interesting to see how the pilot rolls out and how those are addressed, and how GSA handles that issue, and how the platform providers do as well.
Well, Roger, I want to ask you just a dumb question, because that's what I get to do as the professor. Dumb question. So if you look at the back and forth in the Q&A between GSA and the vendor community and responding offers, GSA said there really isn't really a cybersecurity issue here because these portals are not connecting with the government networks. Do you think that's true?
I'm not a techie, and I don't play one, and but you are connecting in a sense. You're going on their site and ordering if you're a buyer. And I don't know what that implications of that are or not. I leave that to others with the expertise in that area. Just real quick, I'm going to finish up. Post facto forensics, that just goes to the balance between screening up front versus taking a look after the fact and what you can learn from that. Ownership of data, that's akin to the counterfeit issue. No, the ownership of the data goes to the transactional data and the ability to control that. The intellectual property issues are akin to counterfeit. And the one thing I didn't mention on the first slide is the issue around organizational conflict of interest that I think is going to be interesting, fascinating, watch it play out just generally is, where a platform provider competes directly against third-party suppliers. In tradition, this is like government contracts, like you got some great questions for your students, FAR Part 9. You are managing the market, you're essentially managing access to the market, but you're also directly competing against those who are entering and utilizing your market. In traditional government contracts, that's an organizational conflict of interest. So it'll be interesting to see, whether GSA addressed it, whether they waived it, how they handled that issue as well. And it even goes to issues about product placement. Do companies pay more for their product to be placed and come up earlier in the search? Is that consistent with, value to the taxpayer kind of questions that, go to the public fist? It's going to be fascinating. Lastly, just metrics. I think it's important, it'll be important to see GSA lay out the metrics of how success will be managed, how success is measured, so all stakeholders get an opportunity to weigh in and take a look at that and, and see how it goes. It's a new channel, it's a different channel, it's a pilot, but you've also got to measure, assess, and report on it as well.
I just want to flag with you, Roger, on the organizational conflict of interest. So the organizational, for our European or our foreign guests, the American law regarding organizational conflict of interest is pretty well developed. It's like a personal conflict of interest, but it's held by a company if the company has a conflict of interest. And that's been developed since the Kennedy administration. It's developing now in Europe under the Fabricom decision in the Court of Justice for the European Union. It's recognized in the European directive. So that area of law is developing abroad, but it's a big deal here in the United States. And when the FAR was written, Roger, in 1984, the Federal Acquisition Regulation was published. There was a policy decision presumptively not to require vendors to flag organizational conflicts of interest. This solicitation is an exception. This solicitation says that the portals have to flag organizational conflicts of interest going in. And as you say, while it's possible that the agency could have waived any organizational conflicts of interest in the formation process, it's as big a deal afterward as well, whether or not there's an ongoing organizational conflict of interest and whether or not the portals disclose that. It's a huge deal. It's a huge burden that's been put on the portals.
Right, and it's fundamental to government procurement in the context. I mean, maybe a commercial practice. I mean, I know some companies, you may or may not agree with that, but but in the federal context and government context, when you're talking about the public fisc, ensuring a level playing field is paramount, and that's what that issue really goes to.
It really is. It goes back to this last bullet you have, how success will be measured. During the Q&A, someone said, hey, this is a little crazy. You're having the portals assess themselves on how well they're doing in terms of saving the government money. And they said, this is an organizational conflict of interest. And GSA said, no, we'll accept that because it's a normal commercial practice, as you point out.
Right. Well, I don't know how you yet. I mean, you've got to have a third party. I mean, I don't know how you get, it just undercuts the platforms themselves. If they're the ones providing the data and measuring success, you want a professor grading the paper, you know, not the student, right? So that it validates success. So, and I want to mention Thomas had a great comment about training in particular, and that's given the way this is being laid out, and I know GSA will be doing a lot of training and outreach, but to the extent, you know, the 5 agencies that did sign up to participate in the pilot, there's going to need to be a lot of training of folks just so they understand some of these parameters, because it's just going to, as I mentioned, just highlight the compliance requirements. And in a certain sense, you know, in the government-wide contracting context, it's being shifted where GSA does the vetting to now it's really the buyer is the one who's going to be making those decisions, and the reliance on the marketplace provider, that's not clear other than through, you know, what they promised the government they would do.
You know, just a quick comment to that. It's just almost an awareness of the importance of certain things that they may not think about as a buyer. I mean, just for yourself, Roger, when you get after you take an Uber ride, or how often after you go to a restaurant, do you click on the review and you and give a extensive commentary about how great the meal was?
Right.
You do it out of the goodness of your heart, or the general community, or you just want to, you know, normally you want to just complain if it's bad, but if it's good. So it becomes almost an obligation to provide feedback for the rest of the buying community, to create that awareness. And good quality feedback is highly needed in a system like this.
Right, and that's a great point. And the flip side of that is, then again, in the unique government world, there's almost due process rights, for lack of a better term, where if someone gives somebody a bad review, a contracting officer or program manager, that company typically has the opportunity to provide, you know, their response or feedback on that review. Is that correct, Chris?
Yeah, and that's kind of interesting. I wasn't sure whether or not, as a lawyer, Roger, I had thought that the government's reluctance to allow users to post their own reviews, I didn't quite know where that's coming from. I think Roger's, as 2 lawyers, we're confirming we think that's probably grounded in due process concerns, that if government users can start popping up evaluations, then the companies will demand an opportunity to respond under the due process clause.
And the portals provide that ability now. I mean, your regular commercial Amazon does that. For sure. It becomes basically a clearinghouse for information that a back and forth goes on.
Okay. So there are a couple of questions that are pending that I want to walk through for audience questions. We've been answering audience questions as we go along in the chat, but we received some earlier. And the first one is from my colleague, Kristen Iddig, who I can't reach her. I think she's standing in line at the DMV, so I won't embarrass her by pulling her in. But Kristen asked this question. She says, why is this initiative really important? If government users can already use purchase cards to buy from commercial platforms such as Amazon, why do we even need this initiative? What is it? What is new about this? Roger, how would you respond to that?
I guess, you know, that's a good question. GSA, I think, would say, well, first of all, it's a statute. Okay, so you got to implement the statute. Yeah, give GSA credit for that. Absolutely. You know, Congress mandated, you know, moving forward on this as a new channel and a new way for government to buy. And I think GSA is taking the right approach in terms of doing a pilot, taking a look at it, measuring it, see if it makes sense in the context of government procurement. And I think part of the goal is to collect, you know, this information from purchase card spend, which is, I think, about 6 to 12 billion. There's an annual addressable market of this type of spend. So taking a look at that and trying to get a handle on that to maybe, you know, okay, we found we're doing all these purchase card transactions. Is there another way to buy it? You know, could we, you know, leverage our requirements more effectively? Could you use EDI, for example, as opposed to purchase card? Because it, you know, companies are, you know, the real world, people move, you know, companies are moving that way. organization-to-organization transactions, that sort of thing. So I think it's a part of an overall effort, in part, to get a handle on that data. And of course, Congress said, please, you shall do this.
So Roger, I want to follow up on that a little bit, because this debate is actually an old debate. In the beginning of the century, the debate was around purchase card data, and now it's around purchase card data going through Amazon. So it's the same debate and different guys. And Steve Schooner and Neil Whiteman wrote on this early in the 2000s and they argued that micro purchase data has to go in the federal procurement data system. It's the only way to make sense of what's going on at this important end of the market. We have to make this data public in order to ensure that there's not cheating going on. For example, the question of people splitting orders. It's very common that people will split orders in order to stay below the micro purchase threshold. And it's actually pretty hard to prove that they did so wrongfully, because it's a question of intent and knowing. If they don't intentionally or knowingly split the order, it's hard to slap people's hands. So there's a lot of splitting that goes on in the marketplace. So their solution back in 2000, 2001 was put all this micro purchase data into the federal procurement data system, make it all public. This data is going to be proffered by Amazon and by the other portals to GSA. What would you think about that? Should this data all become public?
Yeah, I mean, the data, there's not good granularity to purchase card data, but, through other, means, the government does publish its spend each year and spend under contracts, and you can search it and look at it. I mean, I think part of that goes to trying to get some greater transparency around this information, which I think transparency is a good thing, right? So you can understand. The only area where there would be concerns is to the extent there's transparency around purchasing that is supporting national security issues, where adversaries could take a look at, you're buying, hundreds of thousands of pallets of water and sending them to country X. What does DOD is doing that? What does that mean, right? We don't want that kind of information released. So with that caveat, I mean, that's my thoughts on that.
I can speak to that as well. I gave a workshop to GSA on spend analysis, and the level of spend analytics that government has, that GSA has today on GovBuy or any other of the platforms, even GSA Advantage. To your point, Roger, it's not useful. It's not at the right level of granularity. It doesn't have what they call first line visibility, and so I think there's an opportunity to do post hoc. A lot better analysis of spending patterns, be able to trace it to different parts of the government, who's using this, how is it being used, which in turn can drive greater accountability and potentially better, if there's enough volume in certain categories, we can move it onto a federal contract and get savings from it. So that's one of the benefits. I think as far as the national intelligence community, I did a study on them. They have their own procurement systems that are off the grid anyhow, so they're not likely to order it on Amazon. So they've got very interesting procurement practices there.
So I want to go back to this basic question, Roger, that Kristen asked, and really focus in on, because to a certain extent, we're going to show our age. We've been around for a long time. We've watched the explosion of the GSA schedules in the 1990s. And what really, I think, made the GSA schedules explode was almost a psychological, social thing, that suddenly you had a pathway to procurement that procuring officers knew they wouldn't be criticized for. They wouldn't suffer a loss of reputational capital if no one criticizes you for using the GSA schedules. They're okay. It's a good housekeeping seal of approval. Do you think the same thing will happen here with this new initiative, that a good housekeeping seal of approval will surround these new portals and therefore they'll take off over time?
I think that's to be seen. I think the pilot should assess that. I go to the comments Robert made earlier with regard to the challenge around counterfeit products. I think that's where the focus in terms of, ensuring the integrity of those marketplaces is going to need to go to try to address that.
Okay. The next question relates to that. It's the question the person asked, in the healthcare industry, where there's a lot of sensitivity to quality, and there's a real threat of counterfeits coming in through these portals, is this the right vehicle? And the answer to that is, the technical answer to that question is the debarment issue that we talked about before, that the DHS report specifically calls for debarring those entities that posing a lot of risk of counterfeits. And there's a quote here from the OECD pointing out that counterfeits are a big problem. So there's a debarment solution, but Roger, I want to ask about a complementary solution. I want to ask all of you guys, because this is really where public and private supply chains start to overlap with each other, okay? The idea historically was that in public procurement, we have an intermediary, an agent called the contracting officer. And the contracting officer too often is indifferent to outcomes. Abe Young, who's in the chat right now, he's co-authoring a piece with me right now. So he wrote his thesis on this. He pointed out that half of the boots used by the soldiers that are being deployed abroad, half of the boots are not the boots that are issued by the Army. That half the soldiers who are being deployed abroad leave their Army boots in their lockers, and when they're walking onto that aircraft, they're wearing boots they bought in the private marketplace because the Army boots are deficient. It's an agency problem. The idea is that the contracting officials who are intermediaries are too often indifferent agents. Now we take those intermediaries out. We're allowing the users to make direct purchases with the idea that the users are going to be more sensitive to quality. And therefore we can throw out things like a traditional competition requirement, say, as long as the users can see 2, that's enough competition because we trust the users to make the right decisions. And we can, in theory, that same principle could apply to this question, which is we can trust the users to make sure they're not buying counterfeit healthcare goods because the stakes are so high for the users. From your perspective as supply chain professors, Roger, your perspectives, is that a fair assumption that the users are conquering this issue of agency? The users are going to ensure that the government only really gets best value?
I'll jump in with that one. Users want quality. They don't necessarily want value. I mean, is it their money? See, when you go back to the individual, the soldiers buying the boots, it was their money and it was their feet. So you had both cases. In this case, we only have in my view, we have the users using, but it's still not their money. And so I think we still have an issue there, and there needs to be an ability to understand value. I mean, look at yourself when you, do you click the subscribe on Amazon? Do you buy the one-time purchase, or do you buy the subscribe? There's a value choice there and a judgment of what is bought. And so I think there's some, you're still not quite to where we're thinking right now.
Okay. I would agree with that. I think, in general, we did this study on counterfeiting for CAPS, and 80 to 90% of the counterfeit products that were caught by customs coming into this country were from China and Hong Kong. And so, I think if you start to see, big price discrepancies, I know when I shop on Amazon and I see something that's unusually low price compared to everything else on the market, I go, that's probably a counterfeit. So it is a bit of a buyer beware situation, but I think I think that's something that Amazon honestly will have to address. They've been avoiding it for a long time. I think it's something they have to take full-on frontal responsibility for with the federal government.
That's
sorry.
Go ahead, Andrew.
No, I 100% agree with what Rob just said, which was exactly what I was saying. Like, especially during that period, and I've seen a lot of cases in Europe of countries and local governments buying because they were the only places where like PPE or medical supply were available currently, having problem with the quality and compliance of these goods to their expectation. And again, it's a matter of the user, but that's my view. I don't think we can put the full responsibility into the user hands. So if you're using a provider like Amazon, I think that to also increase the spread of this type of tool, it's an aspect that Amazon in some ways should address, like with some functionalities through the technology. There should be a share of responsibility. It's still the user money, it's still the user responsibility to make the evaluation, but I wouldn't trust 100% the ability of the user to make a fair judgment of the quality of what is buying.
So I'm going to echo what you guys have said and just say, you know, the federal market is a compliance-driven market. It's a highly regulated market at the end of the day. That's, you know, good for us, right, Chris? Lawyers. But that's not going to change. And I think I go back to one of the things I said earlier is that, you know, this is a program. It is, you know, it's not a process. You know, the micro purchase threshold is a process that allows individual buyers. This isn't being established as a program akin to the schedules program. You know, the disconnect between the two, the dual universes, that over time will evolve and change. And I think there's inevitably going to be more responsibility on the marketplace providers in the long term to ensure the integrity of the markets when they're selling to the federal government. I mean, it's just you look at the DHS report, and that's for commercial in general, but the imperative in the federal space, I think, is going to drive creation of, you know, compliance regimes within this new channel as well. And compliance regimes, obviously, for all the parties involved, but more responsibility on platform providers in the long run. It's too big a disconnect.
Okay. We're a little over time, so I just want to go to the last question. By the way, we've gotten a couple questions in the Q&A, and I apologize. I've been trying to deal with the chat at the same time and not focus on the Q&A. Many of the questions in the Q&A have to do with other agencies that are not part of the initial partner set of agencies that GSA is working with. GSA has made plain that other federal users, other government users that hold the government purchase card will be allowed to use these platforms. So it's not just the partner agencies, but all federal users will, as long as you have a government purchase card, you'll be allowed to use. So we could have a much broader field of potential participants in this, not just the users from the agencies, for example, from the agencies that have not yet joined this initial effort with GSA in the consortium. So one of the hardest questions, Roger, and this really goes squarely into an area you worked with many years, is the overlap between the multiple award schedules, the GSA schedules, and this contract. Now, early on, in an early version of the solicitation, GSA said that if your prices dive below your GSA schedule prices, if your prices on the portal dive below, it may trigger obligations under the price reduction clause, under the most favored customer clause in the GSA schedules. That provision was eliminated in the later version of the solicitation, but there's still questions coming in from the marketplace. How do you juggle between the two? If you have a GSA schedule, how do you deal with sales through this? Should you be worried about the possible compliance obligations and the overlap between the two? Now, what I've posted here is the next slide is a response from GSA that these are two very separate initiatives, that the government, that this initiative, the commercial platforms initiative, is separate from the multiple award schedules. But Roger, does that really complete the picture? Should the multiple award schedule vendors still be concerned about the pricing that they're offering on Amazon if they go to Amazon?
I cannot say that no, you shouldn't be. Just being, you know, I'm not going to go one way or the other. It depends. I'm giving a legal answer. I think that's something that I think would help the marketplaces, the companies who want to sell through it, to clarify, for GSA to make a public statement about it. You know, there was language in the RFP. It was later removed. It was language that was sort of like, it depends, like I just said, like, no, it's not a transaction under your schedule. It's separate for those purposes, but you need to look at your, you know, your terms and conditions, whether it could potentially trigger the price reduction clause. I think that's something that, you know, is, again, we're in a pilot situation. It's something that GSA, I think, should address with its industry partners so they can make sound decisions on how they want to participate in this platform, and what does it mean for their schedule contracts as well. So,
okay, thank you. Any last words from our other professor participants?
It's been a pleasure to be here today.
Yep.
Thanks for
Okay.
putting this together, Chris.
Thank you very
All right.
much. Yes.
Thank you to all the members of the audience. And as I said before, we're going to be posting this on publicprocurementinternational.com. The recording will be posted and all the other materials are available there as well. Thank you all for joining today's session, and I look forward to seeing you at the next webinar. Thank you all, gentlemen. Bye.
thanks.
Thank you.
Yeah.